3 weeks into a new administration, and now the focus turns from the commander-in-chief to the courts. Let's talk about why. I'm Jenna, and this is Smarter News. 22 days and counting. That's the number of days into the new Trump administration. And we're doing a mini law and order segment today for you because the news really warrants it. One of the fundamental questions of the last 3 weeks is the following: how much power does the Department of Government Efficiency truly have? And that's something the courts are currently tackling. And here's just one case in particular involving DOGE and the Treasury Department. About 10 days into the new administration, the Treasury Department did something new. It allowed special government employees access to its central payment system. This includes payment records to federal agencies like wages for federal employees, VA benefits, Social Security, you get it. Shortly after this became public, though, 19 states joined together and filed a lawsuit arguing that essentially DOGE should not have this access. More specifically, that the access granted to these special government employees violates existing law. And on this past Saturday, a judge issued a temporary timeout to examine this case. And this means that for now, DOGE can't access this information. The judge said he had concerns about security. Elon Musk clearly disagrees. He's arguing that the only way to root out waste is to actually see how this money is being spent. So now on this coming Friday, the judge may issue a ruling that could shut down access to DOGE completely, or perhaps allow it, or maybe wind up somewhere in between. But no matter the outcome this week, we do expect this argument to be ongoing and there to be an appeal process, several rounds of legal arguments. And eventually we may get more insight as to what the DOGE can and cannot do, but also this could wind up before the Supreme Court to consider. What does this litigation show us? Two things. One, easier to describe than the other. So let's start first with momentum. Momentum matters for both the executive branch and the courts. Momentum enables DOGE to start pouring over financials quickly, to start making decisions. But momentum also empowers the courts to act quickly and to decide if DOGE should or should not have access. And although things are moving fast, momentum can actually be an advantage towards both action and answers. The second thing to consider is harder to predict and harder to articulate. But one thing that both a judge or a president cannot control is the passing of time. Once a new idea or a new way of thinking is released, it's kind of like a genie out of a bottle. The decisions made today by the executive branch can have consequence even if the courts later come back and say, wait a minute, you overstepped. So yes, the courts can step in and limit the executive branch's power, but in the meantime, consequences already happened. People's lives have changed, programs have ended, and even if they restart, if a new way of thinking influences Congress or the public, that's something that falls outside the power of the judicial branch. It also falls outside the power of the executive branch. That's a harder part of the story to cover, but I think we need to consider it even this early on in this administration and this early on in the litigation process. Has our way of thinking about government efficiency changed? I'll let you ponder that, but there is another legal story I want to make you aware of because the stakes are really high and has nothing to do with DOGE or the president or executive action, and it's not getting a lot of coverage. The case that I'm about to share with you may indicate whether we're going to see another big case about abortion law in America wind up back in front of the Supreme Court. And we already shared a little bit of this with you back in January, so let me build a little bit of a foundation for you with this Texas case, and then we're going to move on to a case out of Louisiana. So in Texas, the Attorney General filed a lawsuit against a New York doctor for prescribing what's often referred to as an abortion pill to a woman in Texas. Texas argues the New York doctor broke the law in part because she did not have a license to practice in Texas. The doctor in question is a doctor who has advocated for abortion access. Her name is Dr. Mary Carpenter. That's going to be important. New York responded saying that essentially New York State would shield Dr. Carpenter and any other doctors from litigation from states like Texas. This is an ongoing civil suit, not a criminal case. But now we have what is described as the first criminal prosecution of its kind with a similar but not identical storyline. This is out of the state of Louisiana. Louisiana, as some of you may know, has some of the most restrictive abortion laws in the nation. A grand jury in Louisiana chose to indict Dr. Carpenter, that's the same New York doctor, for allegedly illegally prescribing abortion medication to a minor in the state. Prosecutors in Louisiana have issued an arrest warrant for this doctor in New York.
I am proud to say I will never, under any circumstances, turn this doctor over to the state of Louisiana under any extradition request.
Just pause here real quick. In both of these cases, the women at the center of these stories who took this medication, according to the filings, have not been charged with a crime. And according to law in both of these states, they will not be. Both, according to prosecutors, wound up in the hospital due to complications from this medication. And from our understanding, that's how the cases got more attention and law enforcement got involved. In the meantime, the New York governor signed a bill in early February. So New York doctors have the option to not put their names on prescriptions, but maybe just list their practice, trying to, again, shield the doctors from prosecution. But now we could be in a situation where the pharmacy who goes to fill a legal prescription can be subpoenaed or even charged with a crime for carrying out a prescription from a doctor of another state. And that raises questions about, how does a pharmacy operate in this sort of environment? So you can see it's complexity upon complexity, a lot of legal questions. We have states with more permissive abortion laws. We have other states with very restrictive laws. And a question of what does the Constitution really say about who wins in these situations? And I say wins with quotes, who actually has the legal authority. This is why we could see these cases wind up in front of the Supreme Court. And it's hard to do, but take abortion out of the equation just for a moment. It's really a question. There's a fundamental question here about state power and who has it. So what do you think about this? Let us know. hello@smarternews.com. I look forward to your thoughts. It's just another story we're going to keep an eye on for you. In the meantime, thank you for your support of quick, concise, nonpartisan, Smarter News. Have a great day.